Good morning, everyone. Jacqui Brauman here from TBA Law. So today is a longer information section. So we're doing these once a month, Facebook Live. We are advertising them as an event so that you can see that they're going to come up, you can see the topic. And it's our hope that if the topic is of interest to you, that you'll jump on and ask some questions if you have any questions about the particular topic that we're running. So today I'm talking about estate planning where there's vulnerable beneficiaries in the family. And one of the reasons why I chose this topic this month is because World Down Syndrome Day is this month. In fact, I think it might be today or maybe it's next Friday. Anyway, it's this month. So what is a vulnerable beneficiary? A vulnerable beneficiary is usually a child. So where parents are making their wills, they usually leave everything to each other first and then they want to leave everything equally to their children. But they might have a certain child that doesn't manage money well. Now, that child might be a vulnerable beneficiary. So I suppose there's a few categories of vulnerable beneficiaries. There are beneficiaries with disabilities, and that's the main reason why I'm doing this topic today. So people with intellectual and or physical disabilities might not be able to manage their own funds. They might not be able to live independently. So they're not someone that you really want to leave a large lump sum of cash to in your will. So we're going to be talking today about ways to do it better than just leaving them a lump sum. So other than people with disabilities, other categories of vulnerable beneficiaries might be someone who has a gambling problem or other addiction problems, so drug and alcohol problems. Again, they might not be the kind of beneficiary that you want to leave a lump sum of cash to. Some parents in the past have been worried that if they left their child a lump sum that they would be dead quite quickly from an overdose. Or the final category of vulnerable beneficiaries might be potentially someone who is in a domestic violence relationship. So you want to protect the funds for your child and make sure that they're not disappeared or used by someone else. All right. So those are the main people who are vulnerable beneficiaries and the reasons why we have certain things that we can do in wills to make sure that they don't get a lump sum and then the money just disappear. So having said that, we're going to primarily focus on people with intellectual and physical disabilities who can't manage their own money, rather than the other categories. So what can we do in our will rather than just leaving them a lump sum of cash? So there's basically four main options that I explore with parents to work out what may be best for their child. The first thing that we explore is what's called a special disability trust. Now, someone who is a vulnerable beneficiary is probably getting a Centrelink benefit. So what we have to be careful of when someone is a pensioner, a disability pensioner or otherwise, that we don't affect their pension. So if we leave them a large lump sum of cash or some other asset, it will be counted in asset tests and it might push them off the full pension. Even if it doesn't push them off completely, it can significantly affect their benefits. So a special disability trust is a special category of trust. It's approved by Centrelink, which is the interesting thing. So firstly, a special disability trust can be set up while you're alive or in your will after you pass away. It can be set up for someone who has a disability, hence special disability trust. So they have to meet certain categories or certain criteria rather, for Centrelink to approve it as a special disability trust. So the whole thing has to be sent into Centrelink for approval. If they approve the trust, it's about $600,000 that you can put in there that is not assessed as an asset for that person. So you can see that that has a huge benefit. Potentially, rather than cash, it could also be a house, right? But the main purpose of it is to have a lump sum of cash in there so that there is regular income that can be used for the accommodation and maintenance of the person with a disability. Now, a special disability trust usually protects the capital. So the capital amount that goes into the trust can only be dipped into for the benefit of the beneficiary. The beneficiary can't take it out. And hence, on a special disability trust, you also nominate what happens to that principal lump sum once the person with the disability passes away. So if you had 3 children and 1 with a disability, you might set up a special disability trust and leave the 3rd in there for that child, but then specify on the death of the disabled child that the other 2 children would equally share in that lump sum amount that was in the trust. So that is a special disability trust. So like I said, you can set that up in your will, or you can even set it up while you're alive. So this is something that I do explore with parents as well. If there are funds that they want to gift to their child while they're alive, rather than have that child in their will, they could do that. The other interesting thing about a special disability trust is that it's exempt from the gifting rules that Centrelink have. So if you gift a certain amount and you're on a pension yourself, you can be penalised for making gifts. However, if you gift into a special disability trust, the gifting rules don't apply. So that's the other interesting thing about it. However, having said that, those benefits are sometimes outweighed by Centrelink's bureaucracy. So it's something that really needs to be considered fairly carefully. You can look at setting up the trust and go through the approval process with Centrelink and pull out at any time. So that's fine as well. So special disability trust is the first concept that we have to think about in estate planning where you have a vulnerable beneficiary. The second thing to think about is what's called a protective trust. So a protective trust is an old-fashioned sort of trust. It was established in the legislation that we currently have, which I think started in about 1958. So obviously, maybe not obviously, but trust law has come a long way since the 50s. So the intention of a protective trust was in a way similar to a special disability trust, actually. You lock away a lump sum of cash for the disabled beneficiary, and a protective trust only entitles the beneficiary to the income off that capital. So the beneficiary is not allowed to dip into the capital, generally speaking. So that is a pure protective trust. The problem with a protective trust is that the lump sum capital would be counted as an asset for the vulnerable beneficiary. So that might outweigh the benefit of setting up a protective trust. But the benefits, I suppose, are firstly that the lump sum fund is managed by your executors. So using that example again, we've got parents with 3 children. So one has a disability, the other 2 children will end up being the executors of the estate. So they will end up running the protective trust for their disabled brother or sister. So I suppose that makes it at least nice and clear about who is running it, and that can't be altered. And the beneficiary can't make demands really on the executors because they don't have many rights whatsoever. So if there was a gung-ho social worker who got in there thinking that they could undo this trust and get a whole lot of money for their client, the disabled person. Whether it was in the best interest of that disabled person or not, they wouldn't really be able to do anything. So that might be the benefit of a protective trust in some circumstances where there's some concern about ongoing control of that lump sum. I have also actually written up some more flexible protective trusts and actually put in the facility for the executors to be able to dip into the capital if need be for the beneficiary. But it's fairly rare sort of trust to be able to use. All right. So we've covered off two types of possibilities that we have in estate planning where there is a vulnerable beneficiary. The first being a special disability trust, which is a trust approved by Centrelink, and the second is the protective trust. The third is a type of trust as well. It's a life interest. So this, and it depends on the flexibility that you build into a life interest, but there are some benefits, pros and cons for this trust, just like the others. So firstly, a life interest is essentially setting up a beneficiary with an interest either in a property or a lump sum of cash for life. Now, depending on how it's drawn in the will, again, usually the executors are the trustees. So they would look after either the property or the lump sum of cash. Most of the time it's property. So the example would be, again, we've got the parents with the 3 kids. One child is a vulnerable beneficiary, has a physical and intellectual disability, so lives at home with the parents. The parents want to allow that child to continue living in the house that he or she is used to for the rest of their life. The issues that they face is, well, firstly, if the person can't live independently, who is going to live there to help that child stay in that house? But the second thing that we can do is build in a whole lot of flexibility around a life interest. So the main residence might not be suitable for that person with a disability to stay in if there's no one there to stay with them. So we can build in the ability to be able to sell the main residence and transfer that life interest into another property. So it might be far more beneficial to downsize and get that person into a unit. And what can be done is the capital from the sale of the family residence is used to buy the unit, and then the leftovers can be invested, and the income from that investment can be used to help the beneficiary. So it can be used potentially to help pay for someone to come in to the house daily, potentially to help in-house care. A life interest is also transferable into a accommodation bond as well. So if they can't live independently and all and need to go into a assisted care facility and they need to contribute to go into that, it can also be used for that. And again, if the whole of the capital is not used for an accommodation bond, the balance of it is invested for the beneficiary and the income can be used for their maintenance for life. So a life interest, particularly over property, the main purpose of it is to, again, secure the capital away, so the capital is not dipped into by the beneficiary, but at least the beneficiary is provided for life. So they won't be out of accommodation, and they should also get some income if there's a capital portion that's invested. But the main purpose, again, like I said, is the protection of the capital. So the will also say that after the death of that disabled person, the 2 siblings who are still alive would share equally in the balance of whatever's left. So that's the third option in estate planning about what we can do for a vulnerable beneficiary. So What we don't want is for parents to come along and say, well, you know, I've got these 3 kids, one's disabled, I don't know how to provide for that person, so we're just going to write them out of the will altogether. So there are so many options about what we can do. So we've covered off the first 3, which are a special disability trust, which is a Centrelink approved trust. We've covered off a protective trust. We've covered off a life interest. And the 4th option is a much more flexible style, more like a family discretionary trust. So again, it's another form of trust, but it's not restrictive like a protective trust. So we're not restricted to income only. It's not a life interest, so it will continue beyond the life of the beneficiary. And it can own property, it can distribute capital if need be, it can certainly distribute income, but it can also have a number of other beneficiaries. So what the parents might do, for example, is set up this flexible trust, specify that the 2 kids who are able-bodied are the trustees of the trust, have the vulnerable beneficiary as the primary beneficiary of the trust, but also have the other 2 children as secondary beneficiaries and their further or extended biological family. So quite often the flexibility is what's attractive about this sort of trust. We don't particularly know what's going to happen in government regulations, tax laws, all those sorts of things over the coming decades. And that's something else, the uncertainty around that parents worry about. Because if their disabled child outlives them by 20 or 30 years, we certainly don't want something that becomes disadvantageous during their lifetime. Hence the flexibility of the family discretionary trust set up in a will could get around a lot of those things. Now, particularly where the family is a really close family and the other adult children who are able-bodied are very understanding and involved and supportive of their disabled sibling, and also that they live locally so they can actually be engaged and manage things, then the more flexible option will certainly be the better option generally, I would say. So there you go. There are 4 main options about what you can do in your will in estate planning for a vulnerable beneficiary. So what I've talked about so far has mainly been for parents who have a child who has something, more likely a disability, that causes them to be a vulnerable beneficiary. But all of this equally applies to the other categories of vulnerable beneficiaries, which could be a gambling problem, another addiction problem, or domestic violence. So again, equally, most of these trusts would also work in a similar situation. The special disability trust, you need to have a disability to the level that Centrelink will approve. Other things for estate planning. So that's talking about the parents' estate planning. We also need to consider the vulnerable beneficiary themselves, the disabled person. So parents get by without having proper powers issued to manage the decisions of their disabled child. The way to do it legally is to go to VCAT and get an administration and guardianship order over your disabled child. It's certainly better to do that while you're still alive as the parents than to not do it and then no one has clear powers after you pass away. So a guardianship and administration order through VCAT can be applied for fairly simply. You don't need a solicitor. All the forms are online. You just need a doctor's report as well to support fact that these orders are required because your child is disabled and doesn't have capacity. If they have enough capacity, and a doctor will say that they do, then we could put powers of attorney into place for your disabled child. If they're, for example, their intellectual disability is not such that they can't comprehend what we're doing, or if it's just a pure physical disability, but they have complete understanding about what is being done, we can actually still do powers of attorney so that they have their own say about who manages their legal financial affairs. Now, the benefit of having that in place while the parents are alive are that it's then fairly easy to transfer it to executors after the primary parents pass away. If we're lucky enough to be able to do powers of attorney, the disabled person themselves can say who they want their backup person to be. But in the case where there has been an administration and guardianship order issued by VCAT, the VCAT would have to be informed if that person has passed away. So the parent has passed, VCAT's informed. VCAT will already have a file on who the other family members are. So all they have to do is investigate who was the next best person. The siblings, for example, could come forward themselves and say, yep, we're happy to do it jointly, or one might come forward and say, yep, happy to do it by myself. But what we don't want is a situation where there are no powers whatsoever and the state trustees end up coming in for a period of time. So that can be really difficult. So from an estate planning perspective, it's not just the parent's estate that we're worried about. It is also the powers over the person with a disability so that they can continue living their life relatively smoothly. And the other thing to consider is also will for a disabled person. Now, if they don't have capacity, there's a lot of difficulty around that. But if they do have capacity, again, a simple will is better than nothing, because there are some people with disabilities, intellectual disabilities, who struggle to live independently but can understand the concept of a will and can do some part-time supported work. And so they are accumulating some money in a bank account. They are accumulating super. So these things do need to be dealt with in their own estate planning. So again, the main purpose of today was just to talk through some of this stuff, to put the information out there. Understand, I suppose, for families who do have a disabled child, that it's not something to put your head in the sand about with the estate planning. There's quite a range of interesting things that can be done that can suit your situation and that can set everything up for your child in the future. So I suppose the process is just to start having the conversation, do some more research, talk to your family members about what would suit best, but then also come in for a conversation so that we can talk through what your family situation is and start somewhere. Because if you don't start, it doesn't get done. So, been going for about half an hour. Hopefully you've been able to pick up some information that could be useful for yourself or a friend. The video will be posted as a permanent video on this Facebook page. So although it's live at the moment, it will still be there if you want to come back to it or if you want to share it later with someone else. Otherwise, I'm going to say happy Friday and pretty much end here. We do, like I said at the start, a monthly information session like this. Next month is actually on animal rights, so watch out for that. That is coming up in mid-April. And I also do weekly, really short information tips on a Monday, generally at 10 o'clock. So that will start up again further to the end of March. I'm having a break next Monday. So my name's Jacqui Brauman. TBA Law is where I work. You're obviously on the page, so you've found us. You can also check us out on our website. Our contact details are there. You can direct message us through Facebook, but all our emails are easy found on our website if you want to email directly. So happy Friday and have a great weekend.